Hi everybody, George Sourris, Empire Legal. Today's topic, it's going to be part one of a two-part series on rental law changes or reforms. So as we know, you've probably seen this in the media, there's been a lot happening in the Queensland property legislation space, in particular with rental laws. Alright, let's kick it off. So, the Queensland Government is committed to working towards a better renting future for Queenslanders. The priority is to provide a strong, balanced approach that protects renters and rental property owners whilst improving stability in the rental market. The Queensland Government is stabilising rents by reducing rent increase frequency to once a year from 1 July 23 as an immediate action to address the cost of living pressures for Queensland households and the challenging conditions in Queensland's private rental market. Limiting rent increase frequency will help improve consumer protections while Stage 2 rental law reforms is progressed to build on the Queensland Government's rental law reform delivered in Stage 1. Okay, so what are these stages, you ask? Stage 1, what's happened so far? The Housing Legislation Amendment Act of 2021 amended the Residential Tenancies and Rooming Accommodation Act of 2008 to progress Stage 1 of Queensland's rental law reform. The amendments delivered rental law reforms to improve safety, security and certainty for the Queensland rental market. We're going to break that down into 4 topics. The first topic we're going to discuss today and the other 3 are going to be in part 2. So, 1. Setting minimum housing standards to ensure rental properties in Queensland are safe, secure and functional. 2. Make it easier for renters to have a pet, which is huge for Queensland. Everyone's got a miniature poodle or something small and fuzzy these days. 3. Ended without ground evictions, providing more certainty about how and when a tenancy can end. And 4. Giving renters experiencing domestic and family violence the right to end their interest in a tenancy with limited liability for end-of-lease costs. Okay, so most of these reforms have commenced, with a minimum housing standard set to apply to new tenancies entered from 1 September 23 and to all tenancies from 1 September 24. This longer transition period for minimum housing standards will support rental property owners to plan and budget for any work required for their rental property to comply with the new legislation. Tenants under residential tenancy will have 7 days to complete and return the entry condition report, and tenants and property managers can authorise emergency repairs up to the equivalent of 4 weeks' rent. Now, renters can have confidence their rental property is safe, secure and functional through the prescribed minimum housing standards, which require 1. Premises to be weatherproof and structurally sound. 2. Fixtures and fittings to be in good repair and not likely to cause injury to a person. 3. Locks on windows and doors. 4. The premise to be free of vermin, damp and mould. 5. Privacy coverings, so curtains or shutters. 6. Adequate plumbing and drainage. And 7. Functioning kitchen and laundry facilities where supplied. So pretty basic stuff, right? That's why they're called the minimum housing standards. Gone are the days, as of 1 September 23, of people living in subpar housing. This is a great move for Queensland. It's awesome for the landlords, obliging them to keep their property up to scratch. And 2, exceptional for the tenants, not putting them in a position where they're committed to a lease in a subpar dwelling. Okay guys, so that's the end of part 1 of this 2-part series. Stay tuned next week where we will cover off the other 3 topics. That'll be coming to you via your inbox if you're on our mailing list, or otherwise you can find this on social media or our website. Chat soon.